Hello, my name is Brian Sikorsky. I'm a independent financial planner and wealth advisor with Stratos Wealth Partners, located just north of Raleigh, North Carolina. Myself, I was born into a pretty typical American family located in a small suburb outside of the Detroit, Michigan area. And while by no means were we wealthy, we weren't hungry either. That kind of really changed quite a bit when my dad very unexpectedly died at the age of 49, leaving me, my mother, and two sisters and a brother to fend for. While we made it, you might say we're here today, our lives could have been much improved had my parents planned a bit for the unexpected. And today, as an independent wealth advisor, my passion is to help my clients and their families prepare for life's uncertainties. I specialize in helping individuals, corporate executives, and small business owners at their peak earnings years plan for the unexpected while transitioning from their portfolio accumulation to portfolio distribution phases. And to do this, I follow a defined financial planning, investment management, and wealth transfer process, including the use of financial planning and retirement income modeling software. I bring over 20 years of financial advisory experience, certification as both an accredited asset management specialist, AAMS, and chartered retirement planning specialist, CRPS. And I hold a bachelor's degree in biology and a master's degree in business administration. My combination of education and experience, I think, really helps guide me on my clients on their financial journey. Now, today we're going to cover a topic entitled Protect What's Yours, Strategies to Safeguard Your Wealth. And I thought this was really kind of timely because there's so much going on right now in the markets and the economy and so much uncertainty. And a lot of that uncertainty can exhibit itself by unfortunately overlooking some things that maybe should be done at this time that would be very advantageous to you. So I'm going to cover this, and this will take about 30 minutes to go through this. So now consider the wealth that you've attained over the years, equity in your home or business, your retirement savings, your investment accounts, or maybe other savings as well. Now, what would happen if you were faced with a lawsuit or a civil judgment, or perhaps you were forced to declare bankruptcy? Have you ever consulted an attorney to discuss the legal options available to protect your hard-earned assets? So today we're going to cover and explore some of the ways to safeguard your wealth. However, it's critical that you work with a qualified legal professional, especially one who is well-versed in this area of the law, specifically as it relates to statutes from your state of residence. So let's begin by explaining the term asset protection. A sound asset protection strategy can minimize the risk of liability while preserving the assets you have accumulated. And how and why would your net worth, could it be at risk? Well, per capita, we have more lawyers than any other country. In fact, I think it's more than the rest of the world combined. And especially when you take into consideration the presence of contingency fees, where attorneys get paid only if they win a judgment, may encourage more lawsuits. Typically, there is kind of a deep pockets effect or attitude. That is, the more wealth that you've attained, the greater the likelihood that you will be targeted by a potential plaintiff. So let's start off by looking at the headlines, specifically some lawsuits that have made the U.S. Chamber of Commerce's top 10 most ridiculous lawsuits. Number one, man trips over Christmas tree and sues. A New Jersey man is suing the owners of an apartment complex for injuries he claimed he suffered because of a recklessly, carelessly, and/or negligently discarded Christmas tree that caused him injury. Negligent handshake. Two Florida lawyers are meeting in court because of a handshake that one of the other attorneys claims left him in severe pain. Woman sues restaurant after falling off a donkey statue. In August of 2015, Kimberly Bond visited the El Jalisco restaurant in Tallahassee, Florida, restaurant, and voluntarily climbed up on the donkey statue, which she says was smooth and slick, causing her to fall. I'm sure the margaritas had nothing to do with it. Massachusetts man files class action lawsuit over fake butter. Jan Polanek, maybe Jan, I'm not sure if it's Jan or Jan, of Worcester, Massachusetts, claimed he ordered a bagel with real butter at Dunkin' Donuts and filed two lawsuits accusing more than 20 Dunkin' Donuts franchises in the state of Massachusetts putting butter substitute on his bagels when he ordered real butter. And you got to get that high class food there at Dunkin' Donuts. Woman sues U.S. government over nacho cheese burn. A woman from Wichita Falls, Texas, is suing the federal government after she alleged a bowling alley employee at Shepherd Air Force Base spilled hot nacho cheese sauce on her finger. She claims that the cheesy injury resulted in restricted work hours and ultimately in the loss of her job. While these can seem to be extreme examples, your assets could also be targeted by creditors or plaintiffs. Claims and lawsuits stemming from car accidents, personal injury on your property, and liabilities involving family members can place your assets at risk. I even saw a recent article about some states that have put laws into place that if someone is breaking into your house and injures themselves, that your insurance company has to pay for their care. Wow. So claims and lawsuits stemming from car accidents, personal injury, and your property, and liabilities involving family members can place your assets at risk. This litigation is more often associated with high net worth individuals, business owners, and professionals such as doctors. But everyone with comparatively modest financial assets, such as a home and a retirement savings account, should consider a strategy to protect their wealth. Now, what is the benefit of having a saving for retirement or a college education if your savings are at risk of being targeted by creditors? An asset protection strategy should be a component of a thoughtful and comprehensive financial strategy. So, there are two main objectives to an asset protection strategy. Number one, minimize the potential risks. These could be physical or in nature. For example, is your home safe for visitors? Are there potential hazards present? Or maybe there are risks in your personal or professional relationships. Are your business dealings handled in a reasonable manner with clear communication? Do you avoid an ostentatious lifestyle? Well, there's a word I haven't heard for a while, ostentatious. Wow. Scrabble, here I come. Have a plan in place to preserve assets in the event something does happen and you are targeted with a lawsuit. Your strategy may involve legally shielding assets from creditors altogether or prompting at least a favorable settlement in the event of a lawsuit. For many people, asset protection is an afterthought or is not considered at all. It is important to shield your assets before something happens. Taking action after the fact could be considered a fraudulent conveyance in which you become accused of illegally transferring money solely for the purpose of avoiding payment of a pending obligation. Generally, this issue arises when a debtor transfers ownership of assets to another party in response to an unfavorable judgment or a knowledge of a potential legal claim. However, a solid asset protection plan is not designed to evade legal taxes or hide assets or to defraud legally filing creditors. One of the first key steps in the asset protection is an analysis to determine what is potentially at risk of being attached by a creditor or lost in bankruptcy proceedings. During this presentation, we'll hone in on a few assets which may be considered protected from creditors, and a good asset protection plan will explore strategies to increase this area. So we're going to discuss some basic techniques such as umbrella liability insurance or homestead protections. Then we'll delve more into complex strategies such as limited liability companies, LLCs, and certain types of trusts. So let's talk about some basic strategies. Number one, insurance. Review your existing home and auto policies to determine if the appropriate amount of coverage is in place. Does it make sense to increase the underlying liability coverage within these policies? If you have home equity and savings, you should consider an umbrella liability policy which can provide additional protection beyond your home and auto policies. Now, I have an umbrella policy and I think it runs me less than maybe $250 a year for like $1 million in additional coverage, which would kick into place if my auto and home policies had been exhausted. Next would be a homestead exemption. And it's another way to protect the primary residence from creditors' claim. The level of protection depends on the length of ownership. In most states, there are caps on the amount of equity that can be protected in a home. For states with a high or limited or unlimited caps on home equity protection, such as Florida and Texas, one way to maximize the protection of a primary residence from claims is to pay down the property mortgage with assets considered at creditor attachment or risk. In this case, you are shifting assets such as cash investment and investments that may not be protected to an asset such as a house that may receive protection from creditors. Consult a legal professional knowledgeable about homestead exemption statutes in your state because these rules can vary considerably from state to state. Next, titling or transferring assets. A simple and inexpensive method of protecting certain assets is merely to transfer the ownership of that asset. For example, one straightforward strategy for protecting a home is to transfer the property ownership from the high-risk spouse, in this case, perhaps a doctor, to another spouse who is considered low risk. There are, of course, certain complications that may arise if, for example, the marriage were to end in divorce, or if the individuals reside in a community property state, such as California. So be sure to consult your financial representative or legal professional. Another factor to consider is whether it makes sense to add a joint owner to an account. For example, maybe a surviving spouse decides to add an adult child as a joint owner of a bank or stock account. There may be certain convenient benefits to this approach, but there are also asset protection considerations as well. By adding a joint owner, you have maybe unknowingly increased potential liability exposure to include the new owner on the account. If the newly added joint owner gets sued, that entire joint account may be targeted by creditors. Some states allow marital property to be titled tenants in entirety, which means that creditors generally cannot take joint assets to pay for one spouse's debts. Likely, it is wise to review property for potential hazards, avoid an ostentatious lifestyle, that's 2 times, and maintain amiable dealings with others, and most importantly, implement a plan before something happens. For many people, retirement accounts represent a large proportion of their overall wealth. When determining whether a retirement account is protected from potential creditors, there are two factors that need to be considered. Is the retirement plan considered qualified under ERISA, or Employee Retirement Income Security Act of 1974? So number two, is the account owner filing for federal bankruptcy under Chapter 7? So retirement assets fall into two categories: those considered qualified under ERISA and those that are not, including individual retirement accounts, or IRAs. ERISA plans are given full protection from attachment by creditors, regardless of whether this individual files for bankruptcy. In the words of the U.S. Supreme Court, Patterson versus Shoemate, retirement benefits under an employer plan may not be assigned or alienated. Examples of ERISA qualified retirement plans include pensions, profit sharing plans, and other employer-sponsored plans such as 401ks. So as you can see in this chart, all retirement accounts receive some type of protection at a federal level in the event of bankruptcy proceedings. However, if the account owner does not declare bankruptcy, those retirement savings may be at risk. At that point, it's important to work with a local attorney to determine if non-ERISA retirement accounts, such as IRAs, receive any type of creditor protection at the specific state level. Now, under federal bankruptcy law, only 529 and Coverdell ESA contributions, not necessarily earnings, are protected from creditors. State law may protect total value or some percentage of college savings assets. 100% of contributions made more than 720 days prior to a bankruptcy filing are excluded from the bankruptcy clause. Up to 5,000 of contributions made more than 1 year and less than 720 days prior to the bankruptcy filings are excluded. Contributions made more than 1 year prior to bankruptcy filings are not excluded. All 529 accounts and Coverdell ESAs having the same beneficiary are aggregated together as one. And to be excluded from bankruptcy, the account beneficiary must be the debtor's child, stepchild, grandchild, or step-grandchild. Some states afford additional protection that may apply regardless of whether the account owner declares bankruptcy. Now, many states provide protection from creditors. Amounts will vary, including cash value, death benefit, and monthly income. Any business owner who may be at risk of litigation by patients, customers, or employees should consider protection from claims against the business. Without a formal business structure, personal assets may be at risk due to a legal claim against the business. The idea is to structure business ownership to make it difficult or at least expensive for someone to access your assets. There are several options a business owner may choose to provide a measure of protection. For example, you can form a corporation in the form of a C Corp or an S Corp, or opt for a limited liability company or limited liability partnership. Because LLCs and LLPs are considered separate legal entities, assets held within them are not deemed to be owned by the individual. Therefore, a primary plaintiff seeking access to the individual's assets will need to pursue the LLC or LLP and not the business owner individually. LLCs and LLPs are generally less complex to establish and maintain. For example, compared with corporations, there are not as many required formalities such as directors' meetings and written minutes. Additionally, LLCs and LLPs may provide superior protection since the legal remedy for a judgment against an LLC member or limited liability partner is what's known as a charging order. This means the ownership interest in the business is protected. The plaintiff does not acquire the actual assets, but it is entitled to any distributions, though not necessarily the case for single owner LLCs or LLPs. Now, this may provoke more favorable treatment or settlements in terms of some kind of lawsuit. Here's a visual example of how doctors in private practice might consider using LLCs to strip out equity from the practice and segregate potential liability exposure. For example, if there is a lawsuit or judgment related to the real estate, the legal claim will not impact the medical equipment or the medical practice itself. I mentioned that LLCs, the use of them to own real estate, can be an effective strategy. So here's an illustration to elaborate on this approach, and in particular, establishing and maintaining numerous LLCs. Let's assume a high net worth client owns several properties in addition to personal assets such as their house and savings accounts. Owning real estate carries with it the risk of negative episode occurring at that location, although it may be impossible to completely eliminate the risk a real estate asset poses. The LLC strategy can at least contain that risk within that particular asset. This prevents other benign assets such as personal bank accounts from being contaminated due to events occurring affecting a real estate holding. In this case, the client owns several properties and should consider establishing multiple LLCs, one for each business asset. That way, the risk of each property is contained to that particular asset and cannot spill over to personal assets or other real estate holdings. So with that, I'll say thank you for joining me. Again, my name is Bryant Sikorsky. I'm with Stratos Wealth Partners. I've placed here on the screen my website at bryantsikorsky.com. And I've got a whole bunch of information here that you can learn about finances or other things that might confront you. I also have an events tab here that shows upcoming webinars that I've got planned. And I have over here the social media icons, but one most notable here is the one for my YouTube channel. And I just bring that up because this presentation that you've just watched, I will be uploading probably later today to this YouTube channel, so you can watch it later at your convenience if you like. And it has, I'd say, maybe 30 or 40 different videos here that might be of interest to you. Okay. So with that, I'll say thank you very much. Have a great rest of your day, and I'll look forward to seeing you soon. Thanks.